And now I'd like to introduce Managing Partner of Bongiovi Law Firm, Gina Bongiovi.
Thank you so much, Danica, and thank you to everybody who is on the call. I'm going to go over a little bit of legal information that you as Nevada business owners should know. Let's start with Senate Bill 483, which passed during the last legislative session, and it's referred to commonly as the Nevada Revenue Plan. And so despite a lot of the efforts that went to defeating the margin tax, a lot of people feel like this is the margin tax in disguise. There are some modifications to it, so let me go over those. Number one is it modifies the gross receipts tax, and it also creates 26 different business categories loosely based on the federal NAICS codes, and each of those 26 business categories has a different tax rate. If your business happens to not fall into any one of those 26 categories, then your percent rate is 0.128%. We have in several instances, you might have a business that falls into more than one category, and the rules are that whichever category will result in the higher amount of taxes paid is the category that you should associate your business with. The other thing that the Nevada Revenue Plan did is it increased some annual state filing fees for certain entities. So for corporations, your normal $200 state business license fee increased to $500. And annual lists, which you file both when you form your company and every year thereafter, those increased to $25 for every entity. So it went from $125 to $150. The Nevada Revenue Plan also made some changes to the modified business tax, which increased the percentage of total wages in excess of $50,000 a quarter. Previously, it was $80,000 a quarter, which means that it broadened the tax base so it applies to more people. The good news is that it did provide an opportunity to offset whatever you're paying for the commerce tax against your modified business tax liability. This commerce tax went into effect this past July and applies to any business that has in excess of $4 million in gross revenue minus some certain deductions, which ironically do not include cost of goods sold. So this is one of the most significant differences between this Nevada Revenue Plan and the margin tax that we fought so hard to defeat, because the theory is that the Nevada Revenue Plan applies to very few businesses incorporated in Nevada. And so this is a relatively complex tax to administer and to comply with, and because it really went into effect on July 1st, it's wise to enlist the help of a CPA to help track all that information and to report it properly. All right, so now that the boring stuff is out of the way, one of the more effective presentation methods I use is telling client horror stories with of course, names changed to protect the innocent. So I'm going to go through some recent ones that have come up in my law practice with my small business clients, and hopefully they will resonate and help you avoid some of these horror stories that some of our clients have been through. So the first one concerns wage claims. So the wage claims are often filed by disgruntled former employees, or maybe not disgruntled former employees, who feel that they have been underpaid for the work they have performed for your business. And they file it with the Nevada Labor Commissioner, and the Labor Commissioner opens an investigation, and in short, the burden rests back on the employer to refute whatever facts are alleged in the wage claim. So this is really where businesses have to be very diligent and thorough in their documentation to make sure that they have the documents to refute whatever is in the wage claim. So in this particular example, I actually have two clients that went through this recently. So in one example, one client had some commission salespeople who, by virtue of the fact they were commissioned, did not have to log in or clock in. There were no timesheets. There were no records to track when the employee showed up for work and when the employee left for lunch and when they came back from lunch and when they left for the day. In the second instance, I had a client who had hired a consultant who, this consultant had his own corporation in another state, his own LinkedIn group that he was administering, his own website for his own company, who also claimed back wages. So in both instances, we went into the labor commissioner hearing and said, well, these people are commissioned salespeople, so of course they don't have timesheets. And the labor commissioner was not persuaded, insisting that in order to not have to pay these outrageous back wages to employees who were simply upset about the fact that they were not working there anymore, the burden was on the employer to disprove those things with timesheets. With regard to the consultant, the labor commissioner investigator said that because the consultant's company was not incorporated in Nevada, they did not consider him an independent contractor. So while I don't know that that is necessarily a legitimate reason for finding the person to be an employee, the solution to avoid either one of these is to make sure for all of your workers, regardless of how they're paid, keep your time records, make sure that you have signed independent contractor and employee agreements that outline all of the duties and obligations. And one of the other things the state of Nevada, both the labor commissioner and the Department of Employment Training and Rehabilitation want you to do is require anybody who you pay as an independent contractor to send you invoices for the services they're providing your company. Speaking of the Department of Employment Training and Rehabilitation, we have audits. So if you're lucky enough to have a DETR audit come across your desk, you may or may not, there's one auditor in particular with a very long Italian last name who's pretty funny and probably should moonlight as a stand-up comedian. But the premise of these audits is to ensure the numbers you've reported to DETR match the numbers that are actually on your books. But what happens is during these audits, the investigator or the auditor will always point out the 1099 contractor line item in your QuickBooks financials or however you keep your financials. And they will look particularly at anybody who's paid more than normal or that seems to be paid more than everybody else. And they'll ask you what that person does for your company. And unless they do something that's completely outside the normal offerings of your company, for example, if you have a plumbing company and the person you've paid as a 1099 is a website designer, that person is legitimately an independent contractor. However, I had a client who has a pool maintenance and repair company who would commonly pick up, as he was heading to Home Depot to pick up parts for some of his jobs, he would also pick up a couple of the day laborers in the parking lot, bring them to the job. They would help with whatever work needed to be done. He would drop them back off at Home Depot, and the auditor informed us that those people not only needed to be recorded as far as employee information, but also needed to be run through payroll. So the solution here, and what's interesting here too is that the State Department of Employment Training and Rehabilitation takes a much more narrow view of independent contractors than the IRS. So for example, I have another client who has a nail salon. And while the IRS will allow people in cosmetology industry, hairdressers, nail techs, estheticians, to be paid as independent contractors, the state of Nevada does not agree. So you want to make sure when you're making the decision whether to pay somebody as an employee or independent contractor that you survive both the IRS analysis on employees and independent contractors and also the state analysis, which is much more difficult to pass. So I encourage, in anticipation of a DETR audit, make sure that you have your independent contractors sign independent contractor agreements, require them to hold their own business licenses, and make sure that they're submitting invoices to you for their services. And in any case where you're in doubt whether someone should be treated as an employee or an independent contractor, while it's very tempting to treat somebody as an independent contractor because you can save some taxes and some fees, when you come up on an audit and it turns out that person should actually have been paid as an employee, it's far more expensive to pay the back taxes and penalties and interest and everything. So when in doubt, treat as an employee. Speaking of the nail salon client, if one of the other pitfalls of miscategorizing employees and independent contractors, so he had 65 techs, all of them were paid as independent contractors. We got an audit from DETR. So not only did the client have to pay back unemployment insurance, but then the State Department of Workers' Compensation got a hold of the file, and it happens to carry with it criminal penalties to not carry workers' compensation insurance. So I had my very first experience going in performing work as a criminal defense attorney, and I would prefer not to have to repeat that. So again, when in doubt, pay everybody as employees. This is something that we've run into with two clients almost simultaneously who happen to not ask us for a referral to a general contractor and both happen to use the same general contractor. Now, mechanics liens enable a subcontractor who actually enable anybody who performs labor or service on a property to file a lien and eventually foreclose against that property in order to recover the money they're owed for that labor, that labor or those services, or the materials, labor and materials. The law here in Nevada is really designed to protect subcontractors from the property owner. So you have, say, a commercial tenant that hires a general contractor, and you have the plumbing guy, the electrical guy, and the engineer who comes in and does work and doesn't get paid. It's to make sure that those subcontractors have some recourse. What the law does not contemplate very well is owners protected from general contractors. So what happened in both of these situations with our clients is that our clients hired this same general contracting company, and that general contractor hired subs to come in and perform the work. Our clients paid the general. The general did not then pay the subs. So the subs then come in and they start filing liens against the one of our clients is a tenant and one of the clients owns the building. So they started filing liens. And so our clients are going after the general contractor to say, hey, look, we already paid you for this and you need to pay your subcontractor. The general contractor who skipped the state and whose license is now revoked. And so this is the other funny part, the general contractors are required to carry a bond, some sort of insurance policy to ensure that there's this chunk of money there. So if something like this happens, the people who are getting screwed by the general contractor have some sort of recourse. So we found out that there's a bond, and the bond is $30,000. Well, one of the clients alone had spent $51,000 with these subcontractors. So as their attorneys, we can make a claim against the bond to say, hey, this bond, you need to pay, ensure that these subcontractors are paid and make sure these liens are released against the property. And so I wrote the letter, and the insurance company wrote back to me and said, yeah, you're not alone. There are other claims that are made against the same bond. And I thought, well, I wonder how many. Well, I got the letter in the mail last week, and there are 19 other companies making a claim against the same $30,000 bond. Pretty sure if we get anything, it will be dollars, like no decimal points. So if you are a homeowner, we're talking residential or commercial. If you're a tenant doing a build-out, if you are a building owner doing a build-out for a tenant, for all construction work that's performed on your property, make sure that you are obtaining lien releases from all of the people that you're paying. The other way that you can try to avoid a situation like this is to write dual checks or double payee checks to the general contractor and to the subcontractor it's intended for. Make sure all of your change orders are in writing, or enlist the help of a construction disbursement account company. There are some title companies here in town that will sort of act as an escrow company. They'll take the money and they'll only disperse it in exchange for the releases so that you, while you're trying to build out your space, don't have to worry about that. This is one of my sort of favorite and least favorite stories to tell. I met with a client in his warehouse. He had a retail showroom and a warehouse. They did some commercial construction projects and then had a showroom. So I meet with one partner, we'll call him John. So John comes in, he's very clean cut, he's very nice, and so we're talking, and I meet the bookkeeper, and I'm in the warehouse, and this gentleman walks in, and he looks like he could potentially be homeless. He's got this dirty undershirt on, and it's stained with food, and it's got a couple cigarette burns in it, and he's got a big chunk of chewing tobacco in his lower lip that's kind of dripping down his chin, and he looks very upset, and I really thought that he had sort of wandered into one of the open cargo doors in the back of the warehouse. And so John gets up and he says, "Oh, this is Gina. This is the attorney that we were going to meet with." And the guy gets really mad. So they go into the guy's office and they start yelling at each other. And I know they're yelling at each other because we're in a warehouse and it's one of those like paper thin walls, temporary walls that they put up in warehouses. So I hear them yelling and screaming at each other, and then John comes out and he sits down as if nothing had happened. And I thought, well, that's kind of odd. So I asked John, I said, well, who is that guy? He said, oh, he's my partner. So I won't tell you the expletives that went through my head at that point, but I said, do you guys have a partnership agreement or an operating agreement or something like that? Oh, yes, we do. I said, please send me a copy of it. So what I was looking for in the operating agreement is something that would have protected John or the business from this partner, who I can't imagine they ever put in front of customers, and who I later found out was verbally abusing several and sexually harassing several of the female employees in the company. So I never did get a hold of this operating agreement that supposedly existed, and one day the nefarious partner went to the bank and emptied out the account the day before payroll, took it out in an untraceable cashier's check, and when we called the bank to find out, why they would let that money go, it was because, number one, he was an owner. Number two, there was no operating agreement in the bank's files to prevent, that contained a provision preventing the partner from pulling all the money out of the account. And banks don't necessarily want to get in the middle of it, so they won't really ask questions. They just, take they look at the Secretary of State. If you're on the Secretary of State, you're an owner. If they don't have anything in writing like an operating agreement saying that you can't do something, the presumption is that you are well within your rights to do it. So the company nearly folded, although this was a couple years ago that I had this issue with this particular client. Didn't hear back from them until about, I'd say, a week and a half ago when John called, and he managed to survive that and pulled himself up and is now back in business. So we don't want, that to be the success story. So make sure that you have an operating agreement. And really, this is not an attempt to upsell either my firm or any other firm, but please do not rely on an operating agreement that was downloaded off the internet. They are very rarely, they're never tailored to your business. They very rarely contain all the provisions you need to protect the business completely, and they are far less expensive than having to negotiate a partnership divorce, which I've had to do very frequently lately, unfortunately. All right, let's talk about lease agreements. You definitely want to have an attorney review lease agreements. Lease agreements, for a number of reasons. I have a top 10 list on my blog, but there are even more reasons than that. Lease agreements, a little bit about lease agreements. Number one, they are always provided by the landlord, which means they are, of course, landlord favored. They are very long documents, usually 40, 50, 60 pages. And the provisions in there can be very detailed, and these are some of those things where the placement of a comma can change the entire meaning of a paragraph. This is really where this kind of thing shows up. So in this particular example, a client bought a nail salon, and she signed a 5th amendment to the lease agreement without reading the entire lease. Now, there was some language barrier involved here, but lease agreements are hard enough to read when English is your first language, much less when it's your third or fourth. So buried deep in the language of the main lease, which the amendment required her to agree to, even though she hadn't insisted on reading it, buried in that language was a personal guarantee. And a personal guarantee basically eliminates the protection of your LLC or your corporation as to whatever contract you're signing. So she ended up signing this personal guarantee, making her personally responsible for paying the lease. So a new owner comes in, he buys the shopping center, and he starts evicting everybody who is even a little bit behind on their rent. So here is where this problem is. Number one, she's a nail salon, so she relies heavily on foot traffic that the rest of the businesses in the complex generate. So as those businesses start to disappear, her foot traffic starts to significantly reduce. The second thing is the CAMs, or the common area maintenance fees. The way they were written in the lease, the way they were calculated, is it was each tenant's portion or proportionate share of the common area expenses. They're sort of like homeowners' fees, HOA dues, but for commercial property. The way it was calculated is her portion versus the portion, so her portion based on her square feet in her store versus the total square feet in the complex that were rented. The way you want this to read is it's the total number of square feet regardless of whether they're rented or not, because of course as one tenant you have no control over whether the rest of the spaces are rented. That's on the landlord. So in addition to losing her foot traffic, with every tenant that was evicted, her proportionate share of those common area maintenance fees went up to the point where the CAM fees were almost as much as her rent. So of course she couldn't afford it, and it turns out she's personally on the hook for the lease because she signed this personal guarantee. So solution here, make sure that you have an expert review whatever document you're about to sign, or that you understand every word of it. And we've had a lot of clients lately come back to us after they've signed something and wanting to get out of it, and there's really not a good way of doing that. So make sure before you sign anything you have somebody review it. We have a lot of single member LLCs or sole shareholder corporations. And what's happening lately, unfortunately, is if that sole owner, who is the only person on the bank account, the only signer on the bank account, the only person on the utilities, the only person really authorized to do anything with the company, that person passes away, the money in the bank account is locked up until the estate plan can kick in. And if they don't have a trust or something that can kick in, then the business almost immediately folds. So where you are the only owner of your business, make sure that you have some arrangement with your bank, whether usually you can accomplish it through an operating agreement or a shareholder agreement that's kept on file with the bank, that in the event of your death or even your incapacity, let's say you're in the hospital and can't pay your bills, that someone else can go into the bank and has the authority to, in your stead, pay your bills and make sure that the company can continue. Are we have questions or not? All right, trademarks. Trademarks are a fun topic because while you don't have to file a federal trademark application or even a state trademark application to be able to protect your right to use a particular name or logo, it makes it a lot easier to shut somebody down who's trying to copy you. So one of the very first horror stories I had concerning trademarks was a family-owned, small Las Vegas-based company that had, through lots of engineering and lots of brilliance and some genius on the part of one of the family members, developed and marketed a particular product. And I won't say the product because it's unique enough that it might be identifiable. So they sink about $50,000 into designing the label and going back and forth with the graphic designer and making sure the label was beautiful and all of their marketing and their brochures and website, et cetera, et cetera. So they, much to their surprise, land a contract with one of the big box warehouse stores. So they are over the moon excited. The client's super happy. They see their product that they've built from the ground up on the shelf of the giant big box store right next to a similar named product that was manufactured by a humongous national, maybe even global company. That global company gets wind of the little guy's product and says, no way, you are going to change the name of your company or we will sue you into oblivion and we will probably win because we had all of our ducks in a row and we have a trademark on this and your trademark, the name of your company, and this is the trick, your company is confusingly similar to ours. And that's where you identify infringement, is if someone's use of the name or somebody's name is confusingly similar to yours, whoever got there first wins, usually. So basically they have to redesign the labeling, the company almost folds. I don't know that they've pulled out of it because that's about the time the market crashed and they were hit pretty hard there. So while it may be, when you talk to certain law firms and certain services, they may charge you for a trademark search. which seems silly. Why can't I just file an application? Why do I have to waste my time with a search? Well, the reason you want to waste your time with a search is so that you're not spending money to file a trademark application that will never get approved. And you also want to make sure that you do your due diligence before you start sinking any money into marketing to make sure that the name or the logo or whatever it is that you want to use has a snowball's chance of getting approved so that you can actually use it. All right, this was a recent doozy that I got. I had this guy call, and the longer I'm in practice, the more my spidey sense tends to tingle when certain people call or when I meet with them, or it's my factory installed BS detector. So this guy calls and he says that he is putting together these two, I call them non-preneurs, because they really had never had, they had not only never owned a business, but they had never really been employees per se. I mean, they were like probably the most employee you could possibly be. They were military guys. So they wanted to start I think it was an electrical engineering firm or something like that, something pretty high maintenance, electrical contracting firm, very high maintenance business, very work intensive. This was not a turnkey operation. And so what this guy that I was talking to on the phone wanted to do is put these other two guys together, and he wanted them, because they were military and they were veterans, they were going to apply for an SBA loan under the veteran banner. They would get the SBA loan, and then they were going to turn around once the loan closed and they got the money, cut the guy in for a controlling interest in the company. And I said, first of all, that's going to violate every tenet of your SBA loan, so these are going to be able to pull the SBA loan. And secondly, who are you to get a controlling interest in a company that all you did really was introduce the two people? And he kept saying, oh, I'm the relationship guy, I'm the relationship guy. So then I ended up talking to the other guys, and each of them had some reservations about dealing with this particular person. And I had told the con man that I was talking to, I said, absolutely not will I engage in something like this, and moreover, I'm probably going to have a conversation with the other two people to let them know that this is going to violate the terms of the SBA loan and that they will probably end up sacrificing that money. So I'm not really sure how that worked out. I hadn't heard from them. So those are just some horror stories from recent clients, and I have some contact information there. If you have any questions, I think Danica will field them. And I am also reachable at any of those methods.
Just want to, again, remind everyone that if you have any questions, you can type them into the chat box on the bottom left corner of the screen, or you can press *7 on your phone to unmute your line. If there aren't any questions, I just want to remind everyone that we will continue Chamber University again November 6th. We are taking a little break next week for Halloween, for the holiday season, and Nevada Day, of course. So have a wonderful break. It looks like we have great feedback from our participants. Someone said great information. So thank you all for joining us today, and I want to thank Gina for presenting today, and thank you all for joining us, and we'll see you in 2 weeks.